nearly 269,000 square miles, Texas is the second largest state in the U.S. In 1900, the state was home to barely 3 million people. By 1920, that number had grown to over 4.5 million. Del Rio, Texas, was one of the many cities contributing to the state's population growth in the 1900s. Located near the border, it had ample water for farming, ranching, and irrigation. And many people from Mexico immigrated to Del Rio to work and raise families. And while the Texas Constitution of 1876 mandated that white and African American children attend separate schools, there was no law calling for the separation of Mexican American children. Despite this fact, some Mexican American students in the Del Rio public school system were segregated.
Del Rio had a school district where schools in the Old Town, which was called the San Felipe neighborhood, were predominantly Mexican American because that's what the school board wanted to see. It wanted to see schools for Mexican American children separate from the schools for Anglo children.
In 1930, school board officials in the Del Rio School District announced plans to expand a local elementary school, which was attended only by Mexican American children. Many parents took this as a sign that the district intended for all Mexican American students to be permanently segregated. One father, Jesus Salvatiera, was joined by several other parents in filing a lawsuit against the school district.
The parents were complaining of unequal quality of education and of segregation of students based on their ethnicity as well as their language. The lawyers came up with a theory of the case that Mexican American students were entitled to equal education based on state law.
The way the superintendents and Anglo school officials tried to spin it is, we're just trying to protect them and give them extra attention. And we can't do that if we put them in the classrooms with the Anglo children, because then they'll sort of get lost in the shuffle, they'll fall behind because the Anglo children have already been in school, for weeks or months longer. But again, the problem with this is that they weren't really interested in the individual Mexican-American school children. All persons who were of Mexican descent were just sent to the Mexican school. There was no sort of testing or interviewing done.
The Texas Court of Civil Appeals ruled that what the Del Rio School District was doing was unacceptable, saying the district's rules for segregation were arbitrary, and all children of Mexican or Latin descent were being segregated without regard to their individual abilities. However, while the ruling prevented school districts from segregating students based solely on their ethnic background, it did not end segregation completely.
The state court out of San Antonio makes this very important decision that racial segregation of Mexican Americans is wrong, because Mexican Americans are Caucasian, not Anglo-Saxon, not this, that, or the other. The general racial grouping is Caucasian. That's the term that the court goes with, right? But the schools insist that this is a group of Caucasians, if we're going to call them that, Caucasians. This is a group that deserves special instruction for other reasons. At that point, the court steps back and says, well, we're not educators. You're the educators. If you claim they need special classes in English language learning, we'll buy that.
The ruling stated that it was the responsibility of school district personnel to classify and group the pupils so as to bring to each one the greatest benefits according to his or her individual needs and aptitudes. This meant that students of Mexican or Latin descent could still be segregated if local school officials determined it was beneficial to the student.
So it all depended on the local dynamics in the community and what the local officials felt was appropriate for their school district. So in one school district, you might have an elementary school where segregation was only up to the 3rd grade. In another district, segregation could be up to the 5th grade. In another one, it would be up to the 8th grade. So you have very uneven segregation in these communities.
After the Texas Court of Civil Appeals made this ruling, many Mexican American students across Texas found themselves still attending segregated schools. Through their attorneys, Jesus Salvatiera and the other parents requested the U.S. Supreme Court hear their case, but they were turned down. Rio ISD versus Salvatiera was the first case in Texas to review local school districts' policies regarding the segregation of Mexican American children. It would be 18 years before another challenge to these policies would come before the Texas courts. In 1946, opponents of school segregation in Texas were paying close attention to events in California and the case of Mendez versus Westminster. That case effectively ended the segregation of Mexican American students in the California public school system, and it inspired parents and civil rights activists in Texas to continue to push for desegregation for children of Mexican and Latin descent.
When Mendez is decided, they play that as leverage. And they go to local school districts, and they go to the state attorney general, and they go to the commissioner of education in Texas. And they say, we have a precedent. We have a precedent. We're going to file a challenge to school segregation.
In the case of Mendez versus Westminster, the argument was made that since Mexican American children were considered to be white, it was illegal to segregate them because California had no specific law requiring it. In the summer of 1948, this same approach would be taken in Texas when Minerva Delgado and 20 Mexican American families brought a lawsuit against the Bastrop Independent School District.
Delgado versus Bastrop is a really good example of segregation that was required so that Mexican Americans were enrolled in segregated class, but it was required at the local level. That means that there was no Texas law that expressly stated that Mexican Americans could not be taught along with Anglos, but there was a local board and local administration that held fast to the concept of segregation. So what Delgado did was it raised the question of how do you prove up a case where you don't have a state statute requiring segregation.
U.S. District Court Judge Ben Rice heard the case. Listening to the arguments of both sides, Judge Rice had to answer the following question. If a public school district maintained separate schools for Mexican American students when there was no state law requiring them to do so, was the school district violating the students' rights under the Equal Protection Clause of the 14th Amendment of the U.S. Constitution?
In the Delgado case, the parents argued that while they were Mexican American, they should be treated as if they were Anglo, as if they were white, and that they were entitled to the same rights and protections as whites. At that time when the case was filed, the only state law requiring segregation was directed against African Americans. So the argument was quite unique. The argument was, we're not African American. You should not treat us as if we were African American. It was not an argument made in any way to be disrespectful to African Americans, but it was an argument that was made that was anticipated would be persuasive to the judge at that time.
In Delgado versus Bastrop, as in Mendez versus Westminster, the court decided that it was illegal to separate out Mexican American children from other white children, that it denied them the equal protection of laws as stated in the 14th Amendment, and that therefore any segregation of Mexican Americans based solely on the fact that they are of Mexican ancestry had to stop.
As in the Salvatiera case, the court ruled that Mexican American children could not be segregated due to their ethnicity, but only for educational reasons. But then, Judge Rice went further, ruling that standardized tests must be given to every student, regardless of ethnicity, to determine language proficiency. Also, segregation was only to be permitted for non-English-speaking Mexican American students entering the first grade.
The court looked at what the educational needs of the children were and were guided by educators who argued that some grouping of the children would be necessary for the children to benefit from the education. The court did not accept a stereotype that grouping was always beneficial, but the court could be persuaded that at early grades, for the purpose of providing educational benefit, not educational harm, that some grouping at the early grade could be permissible.
But despite these new rules, some school districts continue to develop ways to keep Mexican American students separate from Anglo students.
Because of that loophole in the ruling that still allowed for segregation in the first grade, it became, to some extent, a setback for Mexican Americans because they weren't able to counter the various mechanisms that local school officials had before them to continue establishing segregated facilities for Mexican children.
When the courts added that loophole that you can segregate Mexican American school children if it's for teaching them English, then you had superintendents who said, oh, well, I'm not separating them because they're of Mexican descent, I'm just going to teach them English.
But the attorneys in the Delgado case were doing the absolute best they could, and because there wasn't clear guidance from the U.S. Supreme Court back in the 1940s, before Brown versus Board of Education, every small victory was a sign of encouragement and a sign of staying the course.
While it may not have had the impact that the Mendez case had in California, the Delgado versus Bastrop ISD decision can be considered a small victory. The Delgado case marked the beginning of a decade-long crusade to completely end the segregation of Mexican American students in Texas.